available, and we do appreciate that. This investigation started because the Inspector General found classified information in a non-secure setting, and the FBI went to a law firm and found this information. They seized at least one computer and at least one thumb drive. Did you need an immunity agreement to get those?
It was not. I don't think there was immunity. In fact, I'm certain there was no immunity agreement used in connection with that.
So, did it really take the FBI a full year to figure out that Cheryl Mills and Heather Samuelson also had computers with classified information on?
No. It took us to that point in the investigation to insist that we try to get them.
Were you getting them because they had classified information or because there was some other information you wanted?
No, we thought those were the tools, as we understood it, that have been used to sort the emails. And the investigative team very much wanted to understand, if they could, whether there was an electronic hail of how that had been done. Because the big issue was, what did they delete, what did they keep?
But why did you need an immunity agreement? Why didn't they just cooperate and hand them over? The law firm did, didn't they?
Well, yes. That's a question really I can't answer. That's between a lawyer and her client and the Justice Department lawyers. For whatever reason, her lawyer thought it was in her interest to get an active production immunity agreement with the Department of Justice.
The FBI interviewed David Kendall's partner, but did not interview David Kendall. Why didn't you interview David Kendall?
I don't remember. I don't remember that decision.
Going back to this Reddit post, this is put up on July 24th of 2014. You believe this to be associated with Mr. Gambetta, correct?
Yes, I think that's right.
This is the one that Mr. Jordan put up about the need to strip out a VIP's very VIP email address and a bunch of archived email. This is he's referring to a federal record, isn't he?
I don't know exactly which records he's referring to.
How is this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
I'm sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, it depended on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit.
Hi, Liz. I think it really is the FBI. If people are criticizing Director Comey, they're not criticizing all the great agents that work for the FBI. They're criticizing him and his hierarchy for running I can't even explain, just looking at all the press on this case, I do not understand why they conducted the investigation they conducted. It's just out of control. When do you round up all the other co-conspirators and give them immunity? I don't believe that's ever happened in my lifetime.
What do you think?
It's just every time he talks, he gets himself in deeper and deeper trouble. And now the second release on a Friday afternoon of major information. I mean, it's just outrageous. The FBI should not be in that game.
302s, he didn't really provide any information.
I can't remember for sure it being the 302. You've probably seen it more recently.
Well, I saw one 302 said that he pled the Fifth. Obviously, he was given immunity. Another said that there was an invocation of attorney-client privilege at one time in one of the other summaries. So I'm just trying to figure out, what happened with Gambetta. Why was he not able to provide information? He had immunity. This was something that was much more fresh in his mind than previous conversations with Clinton people would have been. And yet you said he was credible. To me, feigning ignorance, that is not credible given the timeline where you have the New York Times saying that this server existed. The House immediately sends a subpoena. he has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where these things are now under a subpoena, and he has conversations with people who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach-bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why did you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI. Again, who knows what people don't tell the director, but I should have asked Mr. Gomer. If there are agents of the FBI who are concerned or confused about this, please contact me. We'll get you the transparency you need to see that your brothers and sisters did this the way you would want them to.
All right, I'm out of time, but I will say just when I was in the military, you had said no one would be prosecuted. I mean, maybe that was just for civilian, but I can tell you that people, if you had compromised top secret information, there would have been a court-martial in your future, and I yield back.
Would the director care to respond to that?
No, fine.
It's a direct comparison to
with herself. So let me ask you this. Secretary Clinton was asked, because she frequently says 90 to 95% of her emails were in the State Department system. Have you heard her say that?
Sir, I can't recall.
Well, it won't take you long to find it. She says it a lot, or she said it a lot. And then she was asked, who told you that? Who told you that 90 to 95% of your emails were in the State Department system? You may find her answer interesting. We learned that from the State Department and their analysis of the emails that were already on the system. We were trying to help them close some gaps. I like the word gaps. I guess if you consider the Grand Canyon to be a gap, then yes, there were some gaps in her email. Did you have 90 or 95% of her emails on your system?
Again, sir, the only emails we would have is what has been provided recently, which was that 55,000 that we got.
Well, no, I'm going back before that, Mr. Fendi. She said you already had them before she gave them to you. You already had 90 to 95%. Was that true?
Again, sir, the emails that we're looking at, talking about the state.gov emails, she did not have a state.gov account. And as far as the emails that we received from her came at that time frame when it was turned to the department and it was processed by a bureau.
But she made this contention before she ever returned them. She said you already had 90 to 95%. She was just helping you fill in some gaps. If you had 90 to 95%, why weren't you complying with FOIA?
Again, sir, what I have in our system is what received by a bureau.
Let me see if I can put that in South Carolina terms that I can understand. If she said that you already had 90 to 95% of her emails before she ever returned them, that ain't true.
Sir, if I may say this, unless she's talking about the files that were sent to other individuals within the State Department, sent to their state.gov account.
Well, how does that capture personal-to-personal emails? And how about the 14,000 that she didn't turn over? Did you have those?
Again, sir, what you're talking about here.
Oh, I understand her position.
Yes,
the fact that I didn't keep them doesn't mean that whoever I sent it to didn't keep it. I get that. What if it's private to private? How are you supposed to have Sidney Blumenthal's emails if it's private account to private account? How do you have that?
Sir, if you look at what we are doing today, in accordance to the Federal Records Act of 2014 that was amended, it requires that if an employee uses their Gmail account or private issued account, they're required by law to send that email to their state.gov account. That was amended in 2014, and that is what I'm briefing and the State Department briefs today.
That sounds like it was a couple of years too late, but I'm out of time.
Thank the gentleman. Now recognize the gentlewoman from the Virgin Islands, Ms. Plaskett, for 5 minutes.